Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about Companies Amendment Bill of 2019. So to begin with the current affair, let us first understand what has happened with that of Companies Act of 2013. So the original act, that is the Companies Act of 2013, was proposed to be amended in the bill, that is the Companies Amendment Bill of 2019. So the bill seeks to amend the original act, that is the Companies Act of 2013, and the Lok Sabha had recently passed the bill. So this is the current affair, and based on this we will see what are the provisions in the amendment and also why it is necessary, what can be the impact. So let us start. Let us first understand what is the issue of dematerialized shares. So under the act, we are talking about the 2013 act. So under the 2013 original Companies Act, certain classes of public companies, those companies are called public companies when a majority of the shares are held by the government. So those public companies, certain public companies can issue their shares only in the form of Demat. So Demat form is when you have a Demat account in the bank and through the Demat account you can purchase or issue the shares. So certain class of public companies can issue their shares only in a Demat form. So this was one provision in the original 2013 Companies Act. Now under the bill, that is the proposed amendment seeks that for the unlisted companies also this type of condition can be prescribed. So under the proposed amendment, it states that for certain class of unlisted companies are those companies which are not listed on a stock exchange. So for certain class of unlisted companies also, they have to issue their shares in the form of Demat or in a Demat form. So that is the issue with dematerialized shares. So second thing, regarding the offences. So how are the offences recategorized? Under the 2013 original act, there were 81 compoundable offences that carry punishments with fine or imprisonment. So these 81 compoundable offences were to be heard by courts in India. So these offences were dealt by the courts or by the judiciary. But under this proposed amendment, 16 offences are considered as civil defaults. So here the government appointed officials or adjudicating officers can levy penalties. So earlier under the original act, 81 compoundable offences were mentioned or listed, and this has to be dealt by the judiciary or by the courts. Now 16 offences are categorized as civil defaults, and this can be handled by government officials or by adjudicating officers appointed by the central government. Now certain penalties have also been amended in the proposed amendment bill. So these are the proposals regarding the offences. Now third one, the changes made on CSR. CSR is corporate social responsibility. CSR is levied on those companies which have a profit margin or a turnover of more than a particular benchmark. So certain changes have also been proposed to the CSR or to the corporate social responsibility norms of the companies. First of all, according to the original act, that is the Companies Act of 2013, what is now considered is that the companies that are required to budget for corporate social responsibility must disclose in their annual reports the reasons why they were not able to completely utilize the funds. So certain amount, a 2% has to be kept aside as a corporate social responsibility. Now if a particular company, if they were not able to completely utilize their CSR funds, in their annual reports they have to mention the reasons why they were not able to utilize the funds under their corporate social responsibility fund. Now the change is that any unspent amount, that is the money that is not utilized under the corporate social responsibility fund, must be transferred to the one of the funds under the Schedule 7 of the within 6 months of the financial year. So if any money from the corporate social responsibility fund is unutilized or not utilized, then it has to be transferred to the funds under Schedule 7, and that too within the 6 months of the financial year. Now fourthly, the change or the amendment is regarding the debarment of the auditors. So under the act, that is the original act, NFRA, that is National Financial Reporting Authority. NFRA has the authority and the power to debar a firm or a member. So it can be a chartered accountant, a member, or any firm, any chartered accountancy firm from practice, and this can be from 6 months to 10 years on a proven misconduct. So based on a proven misconduct, NFRA or National Financial Reporting Authority has the authority and power to debar a chartered accountant or a chartered accountancy firm from practicing up to a period of 10 years. This is according to the original act. Now, this provision has been amended in the proposed amendment or the bill. So, the bill amends this punishment and it provides for debarment of auditors from appointment as an auditor of a company or performing a company's valuation for a same period. So, here the punishment has been diluted. Earlier, the chartered accountant or the member or the auditor or the firm itself cannot practice for a given period that is given by NFRA. So now this has been diluted in the sense that the bar is applicable only to a particular company. A particular auditor cannot practice in a particular company or in a particular firm. Now coming to the fifth amendment, that is regarding the changes that are registered, that is regarding the charges or the registration charges. Under the original act, that is the 2013 Companies Act, companies must register charges on their property within 30 days of creation of the charge, and this is extendable up to 300 days. Now, for this extension, permission has to be granted from the registrar of the companies. Now the bill amends this provision and now the bill changes the deadline as 60 days. So now companies must register charges on the property within 60 days, that is expandable within 30 days, and this can be extended only up to 60 days. Now regarding the approving authority, under the act, that is under the 2013 Companies Act, a change in the period of the financial year for a company that is associated with a foreign company, and this has to be approved by NCL or National Company Law Tribunal. So NCLT or National Company Law Tribunal has to approve the change in the period of the financial year. Now an alteration has been made in this. Now these powers are transferred to the central government. So this bill gives more powers to the central government regarding the functioning of a company or the administration of a company. Now the next amendment or the next proposed amendment is regarding the settlement. Under the 2013 original act, a regional director can compound or settle offences with penalty up to 5 lakh. Now this ceiling has been increased. Now the regional director can settle any disputes up to 25 lakhs. So this ceiling has been increased. Now next one is regarding bar on officer from holding a office. So basically under the 2013 original act, the central government or any shareholders can apply to the NCLT, that is National Company Law Tribunal, for any kind of relief against the mismanagement of the company. Now under the bill, that is the proposed amendment, the bill states that in such a complaint which is given by the government or by any of the shareholders, the government may make a case against an officer of the company on the ground that that particular officer is not fit to hold the office. So here a provision or an empowerment of the central government is seen. That is, the government can make a case against an officer that this officer is incompetent or not eligible to hold a particular office or a particular designation. And after the government makes such a statement, if the NCLT, that is National Company Law Tribunal, passes an order against the officer, then the officer will not be eligible to hold the office in any company for 5 years. Final approval or final word has to come from NCLT, but still we see that there is an empowerment of the powers of the central government in this regard. So these are the proposed amendments under the bill. You can find the PDF of this lecture on our website www.studyiq.com. You can follow my Facebook page for more video updates. Thank you.